Well, I want to thank you both for coming. We really appreciate you taking this time to speak to us about this. Yeah. So we're going to start out with, first of all, you know what, Diane, it's not good. That's not going to, is this not going to work? Okay, don't worry about it. It's not going to work.
Okay.
That's okay. He's going to take care of it because he has your notes. Okay, Diane was kind enough to make sure we knew on the written page where the slides are going to go. So this is so nice. Thank you. All right, so we're going to start out with a question for Diane. So first of all, let's talk about what's the difference between a lien and a judgment, because in the law we keep saying lien, judgment, lien, judgment. What are we talking about?
Well, why don't we go first to just the one slide, slide 2, that has the changes, the statutes that are being changed. And then I'll talk about the difference between the two. So that we'll just leave that up. Just know that the changes are not just to one statute, they're to all 4. All right. Now, to answer your question, let's start first with a lien. There are 2 types of lien. There is the, yes, I grant you a lien. You all do that all day long, right? Deeds of trust, mortgages. And then there is Mickey suing me, and she gets a judgment, which now becomes a lien on me and my stuff. Okay, so a lien is either voluntary or involuntary. Right? Judgments, the only way someone can get a judgment is to go to court. You can't wake up one morning, unless you're a fraud, and create a judgment against somebody. You have to sue. There's an opportunity for defense, and ultimately the court enters an order, which we call a judgment. Now, what do you do with that judgment? It becomes a lien, and effectively, people don't know this, the judgment is a lien, whether it's recorded or not. Now think of title. How screwy is that? All right, so most of us operate by looking at the recorder's office, and that gives us sequencing. Well, no, the only thing recording a document does is to put you in a date certain order. That's all the recording is for. It's just what we have come to use as our baseline. So to recap, a lien is either voluntary or involuntary, and a judgment then comes from the court, becomes a lien, involuntary, obviously. All right, so try not to mix those up, but I do it every day, all day long. All right.
All right. So now with that background, what the Homestead Act is and what it was pre-January 2022, because this law came in January 2022. That's when it became effective.
Right. So let's go to slide 5. And here is the old law. And the essence of this, folks, is really, really simple. And I'll be throughout this, I'll give you the complicated stuff, but then I'll break it down into one-liners. From statehood, Arizona statehood, creditors could never get a lien on our homesteads, period. Okay, that's been statehood. The case law, which we have, go to the next slide, so 6. The case law has supported that from 1922 forward. No judgments can attach to someone's homestead. Yeah, they can attach to their rental property, their raw land. Those will attach, but not to their homestead. So what this law did is to jerk out from under every person who owns a home their comfort of knowing no creditor could actually put a judgment on their homestead, right?
Okay, so now we need to know, I'm trying to go through our notes here. I think you covered the laws now, and then did you want to show?
And then slide 9 is the law today.
Yeah, so there's the law And slide 9 is the new law. And
So.
you'll get copies of these.
Yeah. So basically, it removes the whole thou shalt not touch the homestead rule, and it replaces with it's all yours, just go for it. Okay, to creditors. Yes, sir.
I seem to remember a dollar limit maybe on the homestead.
Exactly. That is the only positive change out of all of this.
Okay, for those on Zoom, the question was the dollar limit on homestead. Go ahead, Diane,
Okay.
and tell us the changes.
And I don't remember when the 150 came in. I've been at this business for too long, but was that like 91-ish or 80
Okay.
something-ish? So we went from 50,000 to 150,000. And now we're at 250. Yay, that!
Yeah.
That was the only, and that was used as a distraction for all of the folks in the legislature. That's all they were told this bill was going to do. That's why they voted for it unanimously in the House. Okay.
So now, Nikki, pre-2022,
Yeah.
when did the title company see homestead protections activated? And what process did the title company use to execute on those protections?
Well, before this new law, it was pretty simple. We had not much to do. We would first identify the fact that you could use a homestead, and that's by the calculations of the numbers and stuff. And so if we determined that you could use a homestead, we had to prove certain things. And one was you occupied property, and it was really your home. And it was so easy to do. We used a utility bill. We used one that had your name and address on it. And then there were certain criteria that we would determine, like, were you 18, at least 18, you hadn't abandoned your home. Then what you did was you signed an affidavit that said, yada, 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 this is my house, I lived here for so long, this is my address, I haven't abandoned it, I haven't used this home before. And we
Hey, your mic is cutting in and out. We're not hearing you well.
Yeah, we're not hearing it well either. So we're trying to figure out what's going on with Mickey's mic.
Oh, well, you guys can hear me in the room though, right?
Just because your voice, not because of the mic.
Yeah.
Let me see. It should be, we tested this and everything. Yeah, it's in there. It's fine.
Don't look.
Yeah, it's fine. Ride the gain rather than the volume. And that should help too. Okay,
Okay, do I need to repeat that then?
just real quick
Just
for
go
those Zoom, yeah.
Just that we used a utility bill to determine whether or not you had a homestead with your name and address. And then after you sign your affidavit, we record it. So it's a pretty simple process.
Okay, so now,
Why don't we stop and let him fix the audio? Otherwise, your Zoom people are not going to be happy.
it's what?
You want this? Let's just put it there and see if that works. Oh, I'm all wrinkled.
All right, we'll do our best here.
Start your morning out all wrinkled. That's just not. You know, this is the first time I've worn grown-up clothes in 2 years. I don't know about the rest of you.
Okay,
Okay, so we're done.
okay, so then we go to, all right, in 2021,
Right.
we had the legislative session, last legislative session, and we had HB 2617, which was introduced. That is what we're talking about today, the Homestead Act. So give a brief history about what was going on during that time period. It left the House super speedy, and then that's when people started noticing what it was. The Attorney General Office was at one point involved in advocating for it. In fact, I think they even were the original backers of it.
Exactly.
And who brought this up? AG's department did. When we read the initial legislation, there were problems. Our problem is that banks, mortgage lenders, and by extension, the real estate licensees who represent clients and homeowners were all affected. So give us a quick little brief overview of what that was. Pioneer
Okay.
Title was involved, you were
Right.
involved. Tell us what that little history was.
Well, I'm going to give you some of the stuff that was behind the scenes. Nobody knew that in 2020, the AG's office dropped this bill. It was killed because of COVID, but nobody had heard of it. What the AG's office was trying to do was honorable. They were trying to patch what they thought would be a hole because they saw something happen in Idaho and they didn't want it to happen in Arizona, which was having the state liens attached to the homestead. Well, Arizona law already did that, clear out. And I asked Don Lawrence, who was the original drafter of this at the AG's office, why he bothered doing this. And he said, well, I just wanted to make sure that it was definitely couldn't happen in Arizona. So with that little innocent intent, along came two of the largest debt collector law firms in town who bought it and then put it in a perspective, not of just protecting the state, the AG's office and their liens, but making sure that all creditors have a right to get to the homestead. So when it was proposed in the House, so Ben Toma proposed it originally because he was the leader in the House. He basically, I've read the testimony on this. There was no mention about all of this stuff about priorities and going after refinance, et cetera. Instead, it was just, hey, we're giving them $250,000. Everybody vote for it. So think of the political situation at that time. We're talking about April-ish or March-ish of 2021, and you've got a split House, Democrat, Republican, that vote unanimously for a bill. Well, there's shenanigans. Okay, so the only time Delbert and I actually heard about this, and that's Pioneer and et cetera, that we actually heard about this, was it had already passed out of the House. And it went over to the Senate. And then we all go, what? No, here's the consequences. Well, then Toma and Livingston added onto it another phrase saying, if there's ever a refinance, creditors get paid before the homeowner gets paid. That's the law today. We'll talk more about that later. But basically, once it left the House, went to the Senate, then we all found out about it, got on our high horses, started beating as much as we could. Title, I mean, that was huge. Lenders never heard about it, never ever heard about it. So the only industries out there that were actually working to try to stop this, or at least somehow control it, was Title and my bankruptcy group. So
And aren't you amazed that no one read the bill
Yeah.
all the way?
none of the folks that voted on it read the bill.
That to me was just dereliction of duty. I don't know if we can call it that, Rose.
We have a question.
Did it change in the Senate?
So there were changes, and initially there was a big retroactive portion.
There still
of this,
is.
And there still is.
There still is.
So we're going to talk about that too, because it's really important that your clients understand that there's a retroactive portion. We had a We Serve member who's also a bankruptcy attorney who is active in down at the Capitol when he found out about it too. And he has been very active, and he is still active in trying to negate some of the issues that are going on, just as Diane. Oh, great. So Mickey, Pioneer Title was vocal during the last legislative session, not only at the Capitol, but with clients and licensees. I remember getting emails from you saying, hey guys, this is what's going on, be aware. So if you were on Nikki's email chain, you would have gotten some of those notifications. So talk to us about some of the concerns that Pioneer Title had with the changes that they were seeing and what they were needing to have changed so that they could do what they do.
Well, one of the major changes is it makes title companies liable for everything. So they sort of made us the enforcer, you know, go get them. And that's not what we do. And we would also be liable financially for anything if something was amiss. So that was a major concern for us. Another concern that I particularly had was the retroactive part. Do you want me to say?
Sure, go ahead. You're on the floor, yeah.
It makes the law retroactive so that they can go back and get liens that you had before. Well, it's against the United States Constitution. You cannot make a law retroactive if it harms the person before they could even do anything about it to fix it. So that in itself means there will be lawsuits. And I don't know how it's going to pan out. It's too soon for us to tell you really anything because it just started and we don't really know what's going to happen specifically in every case or some of the things that may come up that we're not aware of now. But that puts a big onus of responsibility on the title company, and why? It makes no sense. So those are probably two of the major things that I didn't like.
Right.
Mhm.
And then, I remember where automatic.
Right, automatic,
And-
yes.
So you don't have to file because it's now automatic.
So for Zoom people, Craig's talking about the fact that Homestead went from having to file to not having to file, it became automatic. Go ahead.
And now, what is it? It doesn't matter. Because it
It-
sounds like it's screwed up.
Exactly.
Yeah.
It does not matter.
So this is where we come into the next part. So tell us the changes that were made. They're actually in the bill and the Homestead Act today as we sit. Tell us what we're looking at.
Exactly.
And for Parker, we're looking at slide 11.
Yeah, so what we're going to do here is look at hypos. That's easy. I don't know about you all, but I learned from actual facts, not people talking at me. So basically, sales and refinance. You need to call one a tortoise and the other one an apple. They are not related to each other like they used to be. So a sales. In a situation where there is an outright sale of the property, then, and why don't you move on to slide 19. There we go. Okay, so in this case, and one of the other things that you've got to keep in mind, which is crazy for title have to do. If the amount of money that would be going to the homeowner is 80% or more of 250,000, the new homestead amount. So 200,000 is the number. If it's 200,000 or more, now title cannot automatically release the judgments that are out there that would stop the sale of the house. Instead, they have to go to the creditor and ask for permission. But there's some saving clauses in there. If they don't get permission within 20 days, then they can automatically release that judgment as to this piece of property. It doesn't release it as to everything else. So the 80% rule kicks in here. And so in a situation like this one, where the judgment debtor, that's the homeowner, is not going to get more than $200,000, then in that case, it goes through title just like normal.
Right.
All right. But the next one then is where
Slide 20.
slide 20 is where it is between the two, the 80, this is the 80 rule, 80% rule. So in that particular situation where it's between both, now title has to go get permission, and if within 20 days they haven't gotten that permission, they can automatically release. But now we go to slide 3, and this is where there would be money coming to the homeowner that if there was no other change in the law, the homeowner would be getting more than $250,000 because they have that much equity. So in this particular case, then title is going to, correct me if I'm wrong here, Mickey, going to ask for releases.
I'll give you a scenario of what
Okay.
we're going to do.
Okay,
You want me to do it now?
sure.
Sure. Okay, so now, remember how simple it was before this law? So now what we're gonna do are some different things. The when you open an escrow, let's say you waited till opening escrow to find out this stuff. We're gonna send out an opening package to your sellers and buyers, and they're gonna get them. The seller's gonna fill out the ID statement, and hopefully they will return it to us in a timely fashion, which sometimes they don't even open that package. They bring it with them when they come to closing. very excited.
Very bad.
So for the title code. So
Well, you should allow that. You should hunt them
that
down and get it before their signing day. Jeez.
order the preliminary title report, just like you do. And if you remember from real estate school, the preliminary title report is a working document for the escrow officer. Schedule B, if you get one and you look at it now, instead of throwing it away, you will look and see that it says what the escrow officer has to do to close your escrow. So one of the things is pay the taxes. Another one is record a deed. Remember those? So then it's going to list judgments. And when we see those, we're going to have to notify people, hey, you have a judgment, because they probably aren't going to look. And we will notify the seller or the guy that has the judgment. And we will notify the lien holder, the creditor. And that's a notice that they have to receive. That has to be sent certified and return receipt requested. Then we wait 20 days, or within 20 days, the creditor can come up with some stuff. And there's three things they can do. They can answer it and say, oh, well, that's okay. We'll take that money. Whatever you've told us, we'll take it. They can not answer at all, which is like tacit approval, I think. Yeah, we'll go ahead.
Right.
And the third thing they can do, which is not the good thing, is to object. If they object, that means that, and they won't take that money and they want more or whatever, then probably subpoenas are going to be issued and it's going to go to court. And that means when that happens, the title company will be stepping out. Can we see slide 15? I'll show you something on slide 15. It's a list of stuff we have to do. So we have to send all the notice and everything I said, but we have to fill out paperwork that says the calculations of the amount of the equity, like a settlement statement or something. We would have to say how much they're going to get, who's going to get what, all of that stuff we have to do. So what do you think that means? Time, lots of time. And
Absolutely.
although we haven't heard anything yet, no title company has, so don't get me wrong, but don't you think somebody's going to charge you for this? This is what I predict. Of course, I could be wrong. I have a crystal ball, but it's got a crack down the middle, so I don't know what's going to happen. But I suspect that will happen. So before this is over, I'd like to give you some tips that you can avoid some of this stuff. After we do all of this and the underwriter gives us the okay to record, we're going to record if there's no objection. Once the objection happens, it's a mess. There will be lawsuits. And not only that, but I think the seller could probably be sued for specific performance because the buyer went through all this stuff and never.
John, can you come here and try to help me with the volume on this?
What?
I can barely hear it. It's like useless.
Muted on Zoom, Parker. Yeah, that'd be great.
So those are just some of the things that I personally think.
Yeah. So basically, you've got three options here with a sale. Please keep that in mind. One, they're going to get less than the homeowner is going to
I
get
can
less
hardly
than
hear it.
50,000 out of the sale. No problem. Closes as normal. Two, the homeowner is going to get between 200 and 250. So the 80% rule.
I don't know how to use
That's when they've
these.
got the notice. And that is where, if there is an objection from the judgment creditor, there's going to have to be a lawsuit. Three, in closing, the homeowner would receive more than 150 or 250. So again, it's going to have the same result. They're not going to be able to close, and then there'll be lawsuits. But here's going to be the notice problem that they don't know about, but I do. And that's because the owner of the debt is no longer the owner of the debt today, and there is no assignment of debt rule. It's a passing from A to B to C to D to E, and it's now being held in Florida somewhere under the water, and there is no way they're going to get certified. Absolutely. So it is,
Yes.
that's going to be a livid mess. At what point you're even going to be willing to close this loan at all?
Well, we're liable. We're not gonna.
Yeah.
If it's a $250,000 lien, do we think we're gonna take that hit? I don't think so. Of course, I'm speaking for myself.
Yeah.
I have no control over this.
So what this means for you, if you're a real estate licensee and you're in this world, particularly with distressed real estate, you need to be really aware of this and then prepare your own clients for it. And then be really on top of this and working closely with your title company in particular, making sure you're working closely with the lender, making sure you are holding your client's hand, buyer or seller, because this is not a place that they're familiar with. Okay, let's go Dwayne and then Craig.
Courtesy listing preliminary titles, finer doodles. And that's
Yeah.
part of the solution.
One of the solutions that I'm going to give you, if you want me to answer the question now, is the ID statement. One of the things that I really object to, a lot of you don't know, I was a realtor, a broker, I managed a real estate company, and so I try to think like a realtor when I do things. And one of the things I thought is that you're really going to have some hard conversations when you go out and take a listing now. And everybody knows that people don't like to talk about money or their situations. You're probably going to outright have to ask, do you have any judgments?
And they're not going to, 50% will not know that they have them because of the shenanigans that goes on with these credit card companies or collection company in not serving the person who owes.
So what you're going to need to do is I would keep a copy of an ID statement with me at all times and whip that little rascal out and say, you know, we need to fill this out. If they even think they might have a judgment, or maybe I have one, I don't know, those kind of answers, you get that filled out. Title companies will do something called a limited, which checks to see if any liens appear. And what will happen is it's $75. I can only tell you what Pioneers is. I don't know what everybody else is, but ours is $75 for lot and block normal places and $125 if it's a sectional or something really weird or odd. So
So Mickey, that's looking at, I'm sorry. Oh, I'm
So
sorry.
the question had to do with what do you do ahead of time as a real estate licensee? So these are the tools you use to
How to-
prepare yourself and your client, find out ahead of time if there's any judgments.
how to be proactive.
Yeah,
if
right.
you think they have it. But remember, when you are asking these questions, there are cultures that will not talk to you about money. They'd rather talk to you about sex than money. This
So-
is the statistical fact.
So Mickey, you're talking there about checking the recorder's records.
Right.
Does that limited report check the county court records
Yeah,
too?
it'll check, and we check your social security number. So
Okay, good.
that's going to
Good.
be
That'll be
the
helpful.
thing that you could do if you even suspect there may be a lien.
Okay, Craig, you were next and then we'll go to
First, seconds.
positioning, first, second.
creditors,
Yeah.
Yeah.
volunteer versus unvolunteer.
Well, we'll get there.
Yeah, we're
Okay.
going to talk
Well,
about that.
I can see a
Yeah,
way of,
absolutely.
Maybe getting around the creditor not getting paid if you have maybe. second or
No,
Yeah.
you're using old law.
Yeah, so
No.
so we're
third.
gonna,
Change the law.
yeah, totally change the law. So the priority that you're familiar with, we're gonna talk about how some of that has changed in just a moment.
That's
So good
scary.
question. What question did you have?
Nikki mentioned that there was a charge on the identification statement.
Charge on identification statement, yes,
No, it's actually for the limited,
for the limited.
Okay, right. Who pays that?
whoever's
pays?
ordering it, so the seller would pay it.
Whoever's paying, yeah, the person who pays for Zoom, the person who pays for that limited report is the person who pays for it. As for, okay, great. Okay, let's,
Upfront.
yeah, it's up. All right, I want to make sure we get in.
Refi.
The refi,
Yeah, we got,
Refi
that's
changes
the
are big.
elephant.
yeah.
The refi is the most important thing here. The way the law currently reads, if you refinance a home and there is a judgment, you want to remember judgments don't have to be recorded. So and there is a judgment doesn't only mean those that have been
Perfect.
recorded. So if there
Okay.
is a judgment,
Slide 12.
then the title will have to go through on refinancing the whole notice, right? And payout is going to be, correct me if I'm wrong, to pay off the existing loan they're refinancing, to pay reasonable costs of sales. If there's shenanigans going on there, that's going to hold up things. Then to pay the creditor in full. Now, in full means interest, attorney's fees, court costs, etc.
Just remember, it's not
Okay.
just the face of the judgment. You
Yeah.
gotta add all that. other-
Everything else.
And maybe there's multiple judgments out there. And only after those are paid, then the excess money that was going to be used for grandpa's heart surgery goes to the homeowner. But he's liable for the whole debt. Now, I'm going to put on my creditor hat for a moment and say, well, he owed the money. But still, that's not what the law has been for over 100 years.
And we don't object, I mean, if you borrow money, you should pay it. We all probably agree with that. But maybe we haven't been laid off from our jobs for 6 months, or we don't have the heart failure, or we don't want to send our kid to college and take out $40,000 from our equity to pay for it. You know, things happen.
So if let's move to keep our time, and then we'll get to you. There are two types of refis. So if you go on to slide 12. Okay. This is the no cash out refi. This is going to be simpler.
Well, the lender will take care of a lot of this because they're already, you know, if you have a lot of credit card debt, you may not be able to qualify. So there you go. So that kind of is the same. It's
the cash out that's
it's
my
a cash out
elephant.
refi that's gonna
So
be a
on to the
major
next
problem.
slide 13. Here's where the borrower is getting cash out. That's when the whole, no, you don't get any of this money at all until after all your judgment liens are paid, then you get balance.
And that's a real problem. If you are taking cash out for a specific reason, I had some people yesterday that had cash out, and they have a specific purpose for that cash. If they had had any liens or judgments, they probably would have gotten zero money.
So if we go to slide 22, you'll see no cash out, really simple. Title company just does what title company does. All right. And then slide 23, cash out, lawsuits,
Right. Lots of losses.
lots of crap. No, see, that's the whole thing. That's why I said that's the elephant. Oh, in the cash out refi, the 250, does it apply? And my answer is no, it doesn't. The homestead goes away. There is no homestead. If there's a refi and there are judgments, there's no homestead allowance until after everything is paid. And only then whatever is left over as part of the refi will go to the homeowner. So I truly believe it is malpractice for anyone to reference refi without doing what these two are suggesting you do, which is your homework. I know you're not getting paid to do all of this stuff, but it's your job now.
And you won't be as involved in refis just like you aren't now, but you will have people call you and ask you questions. And my deal is you don't need to know every little nuance of this bill.
Right.
What you need to know is be aware this happens. If you have a question, get help so that you can protect yourselves because you're the experts, right?
And think about if you have a client who wants to refi so that they can purchase a vacation home, they want to do their small investor, whatever it is they're doing, that may impact you, right? So you think you're going to go out and help them with a house and they can't get the refi. There's just some basic things you should be aware of in your practice. Okay, let's talk about prioritization, deed of trust. What does this mean? Company liabilities.
Your guess is
Slide
good.
16. I should have told you at the very, very beginning. This is like a Frankenstein slideshow presentation. And that's because back when we were fighting like mad dogs to stop all this train and then it passed, Delbert Evans at Pioneer and Scott Malm at Gus Rosenfeld, Larry Folks at Folks and Something. He's creditor's attorney. And I got together and we did a big, long 2-hour presentation, which is free. And I'm assuming you're going to give them the URL
Yes.
link
Yes,
to
I am.
YouTube
Yes.
for that whole presentation. So we did that, and each one of us prepared our own little material. Oh, and Ken Neely, who is also a debtor's attorney like I am, we did our own presentation and we put it into this 2-hour thing. Well, these beautiful ladies called me and said, Diane, do you want to come out and play with us? And I said, sure, but let me just kind of, you know, cobble together what we had before and update it with a couple of cases. So that's why you see this disjointedness that's going on. So I apologize to you, deal with it. Okay?
Right with that coming up, right with the fact that some of you people were saying about answering some questions, or real estate agents are answering questions. Remember that one big thing, we're not an attorney.
You don't have to be an attorney. This is called issue spotting. And
Yeah.
all of us, attorneys are not, all of you know that you need to issue spot. Are you dealing with the owner of the home? Are you dealing with the nephew? You know, I mean, you've got to issue, not that it has anything to do with this. I'm just saying you as a realtor need to look at the baseline stuff. This becomes now a baseline thing, which means you need to have, excuse the vernacular here, a come to Jesus meeting with this proposed owner of the home and help them understand that their answers need to be true and accurate and thorough in order for you to even start doing your job properly, because you've got 5 other people waiting down the road that you need to get to.
And the important thing is that when you ask those questions and you have suspicions, you know who to send them to. You need to go talk to your title company, you need to go talk to your attorney, right?
Right.
So just like other things that we talk about, potential tax consequences of some actions, it's go to your CPA, go to your attorney, right? This gives you something else that you need to know about.
So here's Scott Mom's predictions about priority. Because the law is so complicated in the way it's been written, it was very poorly drafted, but the way it's been written and then it's been mutated by people putting stuff, and I put some stuff in and title put a whole lot of stuff in to try and protect themselves. There's holes. And so right now, priority is uncertain. It appears, this is just a guess, that once we pass the line into January of 2022, any new debt that comes on is in order of priority. It doesn't matter whether it is a mortgage or a judgment. So that's going to change up the whole reporting situation here for you guys. So here's Scott's predictions. A deed recorded before December 31 holds priority over the a recorded judgment. And as remember here, you've already now learned that judgments could actually be 35 years old. Okay, as long as it was actively renewed 5 years for a while and then switched to 10, as long as the owner of the judgment was renewing it with the court, by the way, then that is still a good judgment. So again, it could be 35, 40, 100 years old. I don't know. I'm making this stuff up. The next one is a deed recorded on or before 31 from a judgment debtor to a buyer that deed is safe. Again, the whole cutoff was the beginning of this year. Anything that went on before, we should be fine. Anything that goes on after, as in today, we got a problem. And lastly, a deed recorded on or after January 1 is junior to previously recorded judgments because they have been in existence before that new deed of trust went on. Can you see the lending market just screeching to a halt?
Can you guys think of a solution to that? Yeah.
The question keeps popping in my mind is, what would a practicing agent's decision tree look like on a one sheet?
So the question is from Gary, what would a practicing agent's one sheet checklist
Okay,
be as you encountered this?
see if I can make this up, supplement. A, do they own the property? So whose name's on the property? B, are there judgments, whether court or recorded? So are there any judgments out there? And then I guess I would want to know, let's see,
You need to know when the judgment.
when, well, and here, this is going to be even more interesting, and because that has to do with not all judgments were properly renewed. And unless you look behind the scene, it's still a physical judgment that's out there. It just
Right.
wasn't renewed. So think of the litigation that comes out of that. I haven't
That's
talked
so
about
interesting.
bankruptcy because I'm going to do that at the end, but that's another some of your decision tree.
The brokers,
Right.
designated brokers, who are not here today. So this is going to,
Yes,
and they're going to want to stay out of trouble.
yes.
So they're going to.
Absolutely. And that's what I'm delineating the basic outline here.
So here's the thing though, each broker is responsible for supervising their own agents, right? The broker is responsible for creating their own policies and procedures for their brokerage that their agents need to refer to and follow. That means the brokers need to talk to their attorneys and get best advice for their brokerage and their agents. And that's where that's going to come from. But now they know what to go ask, right? I need to pay for a few hours of your time to help me figure out what's going to work for my brokerage and my agent. And I would be checking with my E&O as well. So I would go to my attorney, I'd go talk to the E&O, and I'd say, let's come to a place where my policies and procedures within my brokerage are compatible with E&O, law, liability concerns. And then all the agents just have
I
to come in and
already
do it.
see something with the ones recorded after January. We're gonna have, if there is stuff before that, we're gonna have to go back and try to get subordinations.
Right.
Mhm.
And are they gonna
Absolutely.
give them?
The other thing, only a handful of attorneys understand this yet, are even aware of it. So just like you folks, just a handful of title, just a handful of realtors, just a handful of brokers
Right.
are even on the clue that there's something out there. But I wanted to mention bankruptcy as far as your flow chart. You need to ask them, have they ever filed for bankruptcy? That's important. And did they get a discharge and their case closed? Now, you can double check, as I don't think title on that limited report is going to look at bankruptcy court records.
It will look and see if there is one currently filed.
And
Or
active.
it'll show a discharge.
Okay, but that's going to show the older ones too.
Right.
Oh, good.
Hopefully.
So it
I
sounds
don't know
like
how
your
many years
answer
back
is,
it'll go.
yeah, your answer is the limited report.
Dwayne, you had a
A
question?
couple things, so BB for 20-some years.
Right.
The key question you guys brought up is you have to have the tough conversation.
Mhm.
And you've got to teach your agents to have that tough conversation. I know that Matt Connorelli had a couple of comments you've been on call.
Oh, is he on Zoom?
Yes.
You put it on, is he on? Okay, go ahead, Matt.
Hi, all.
For those who don't know, is the Arizona Association of Realtors Government Affairs Director. So he's very familiar with this because he's the guy down at the Capitol. Go ahead, Matthew.
Well, I just wanted to clear up a few things. As Diane said, there was a lot of work done on this. We worked on this. The bill was introduced in January. Well, it was introduced in 2020, failed that year. It was reintroduced in January of 2021. It didn't pass until May of 2021. And there was a lot of stakeholder work on that. Ultimately, the Arizona Realtors, the Mortgage Lenders Association, Arizona Land and Title, all were neutral on the bill and at the table. So there was substantial stakeholder work that was done. And the reason the Attorney General's office introduced this is because of a lawsuit referred to as Castellar. And we were seeing issues pop up around the country that courts were identifying that a homestead and a judgment could be attached to, or excuse me, that a recorded judgment lien could attach to a homestead property. And we saw that reaffirmed most recently by the Arizona Supreme Court, January 27th of this year. And so the Arizona Realtors were at the table, understanding that this case law was out there to clarify state law, to make sure that we were in line with what the courts were. That way our realtors could best prepare for these situations. And so protecting lien priority, making sure that we were in line with what the courts were saying was all very important. We're looking at additional legislation, constantly trying to make this tighter and protect homeowners, but the Homeowners Coalition was also in support of this bill. So appreciate all the information that's been shared today, but we're just constantly seeing reaffirmations from the court, and the opinion issued by Justice Bullock and the other members of the Supreme Court all spoke to in support of the legislation that this could happen since homestead exemptions were introduced in 2004. So just thought I would.
To respond to that, the case McLaughlin that he's just referring to, the Supreme Court, it was just simply a question about there's extra money over the 250. Does the judgment creditor have a right to go after that? And they have always had the right to go after that. That's in 33-1105. They've always had the right to do that. So this law did not change that right. It clarified some things somewhat. But what it did is it opened up the opportunity for judgments to now attach to the house and have to be cleaned up at some later date. And certainly the refinance and the retroactive side of it, those are the two most egregious things that came out of this.
So Matthew's still on, right? Okay.
Yeah, but that, I just thought I'd share that little bit of background so our members know that, you know, we're always there advocating.
And Castleman did not say that they had a right. Castleman specifically said, no, look at 33-964, judgments don't attach to homestead. End of story. And that's what Castleman says. Castleman was the case that he called Castle. So that was the case that came out in 18, I believe it was. And so it was right in line with the case from, and I've got them all in my slides there, from 1922 and forward. Every single case came out and said, no, the homeowner has the right to protect the homestead. But if there's excess homestead and there's a judgment, that judgment creditor has the right to pursue those monies. I have no problem with that.
Which is what you all learned in real estate school, right?
Yeah, and the purpose of the homestead, what is the purpose? Is to protect the family, to make sure that they have a way to go find shelter and a home.
So we have a few more, just a couple
Yeah,
more
but
minutes.
let's get
So I
to
wanna
the
make sure-
bankruptcy
The
side of it.
bankruptcy is the
Yeah.
last one I wanted to make sure we touched on.
Yeah, and then we can go
Yeah.
back. So retroactive, we've already touched on that. You've got some materials on that. Go to slide 37 for the bankruptcy stuff. So when I heard about this, I have an organization called Arizona Consumer Bankruptcy Council, which is a training platform for consumer debtor attorneys. When I heard about the bill, I said, oh my gosh, that's going to mean we have to go back into every single closed bankruptcy, reopen it, and get a decision from the court that judgments can't attach to homestead. Because what we had was In re Rand, which was a bankruptcy decision back in 8, I think it was. I don't remember. Anyway, Judge Haynes in re Rand said, the Arizona statute 33-964 specifically says 2 places, judgments don't attach to homestead. So me as bankruptcy judge, I don't have to give you, the debtor, an order saying that judgments don't attach to your homestead because the law already says it doesn't attach. Well, now the law has changed. So my fear was we're going to have to go reopen all those cases where the judges thought it didn't attach. Now it does attach, and get orders from those courts so that you all have something to work on. Well, Jim Kahn and I got together and we at least crammed in what you see there is G1 and G2 dealing with bankruptcy. So here's the next thing you're going to want to ask your people, and that is going to be very honest with me. I don't care how embarrassing this is. Have you ever filed bankruptcy? And then did your bankruptcy complete? That, because a lot of people file, but it doesn't complete. So that doesn't give them any legal remedies. If it completed, now these two provisions, G1 and 2, will kick in. Because the bankruptcy discharge, which is the whole reason why people file bankruptcy, did away with all of the debt, okay? They are not personally liable for the debt. If it was secured against their home like a traditional deed of trust and mortgage, that didn't do away with the lien that the mortgage company had on the house. It did away with the debtor's liability for that debt. But if he wanted to keep his home, he darn well better pay for it, or his car, or whatever.
Right.
Well, this now has been said, if prior to the effective date of this law, which is 1/1/22, there was a discharge entered, okay, or because I work 13s, which go on for 5 years, there will be a discharge entered and the case was filed before 1/1/22, then these debts don't attach. The judgments by operation of, well, I'm making stuff up now. The judgments, you can come to me, Diane, as debtor's attorney, you can come to me, the judge, and say, dear judge, I need to get a court order from you saying this doesn't attach. If it's a long dead case, if these things, the discharge was entered before 1/1/22 or the case was filed before 1/1/22, Diane, you don't have to bother me as the judge. We already have law that says the judgments can't attach. It's cases filed now that are going to have to do extra work. Now we're going to do, and you're all going to see copies of these eventually, motions to avoid judicial liens. In English, that means judgment doesn't attach to my homestead. I've got a $250,000 homestead. Judgments can't invade that homestead. So you're going to see a bunch of those. But back to your list of questions you need to ask, it has to include a bankruptcy question by either spouse. Okay. And so that's the bankruptcy law. We wanted more, but we didn't get it.
And so, because we're running out of time, I
Yeah.
want to let you know, this is still being discussed in the legislature as of today. So you have sources that you can go to now that you know of, right? Matthew at Arizona Association of Realtors, he knows about this. He's part of the discussion down there. Mickey, Pioneer Title, is down there having a discussion. Diane is down there having those discussions. So as you go forward watching the legislature, if you need an update on what's going on, Matthew Conarelli at AR will certainly return your email or phone call. And you always know two other sources. If you need more detail on what should I ask about attorney, or what about title? What's title doing? What's title thinking? You have an attorney and a title now if you need that nitty gritty detail information, and we'll make sure Diane's slides go out as well.
Now, something you can help us with. So I called Delbert Evers yesterday and I said, okay, what do you need from us going forward? He says, we need horror stories. We need to hear from you. Jane Smith, X, Y, and Z, we need to hear from you. So collect horror stories and get them over, because title isn't doing anything on any of the bills now. Session's already started. No one else that I know, well, there is one sweet little legislator who dropped a bill doing away with all of the changes, but unfortunately he doesn't have, the sponsorship behind him. So anyway, horror stories, get them to the proper people so that when they go back to draft new law or new bills next session, or even the session after, they have a heart story to share. And that's really, having been down there, a bunch of these people pay attention, the legislators pay attention. With Janie, the person with 6 kids around her and in a wheelchair, says what this bill, what this law did to her personally.
So with that, I want to thank both Mickey and Diane for being here. Thank you all for being here. And if you're an agent, work with your broker. If you're a broker, work with your E&O and your attorney, because this is real today. So you have to deal with it as it is today. So make sure you know how to do that. And thank you all for coming. Thank you on Zoom as
Thank
well.
you.